Ariella. Good evening, ladies. Allegiance. Barbara?
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We thank you.
I don't think that's on.
Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 1, Item 1, number 2011-01, All Seasons Motor Lodge. Item 2, number 2012-04, Storybook Homes. Item 3, number 2012-02, Carlson Associates. Item 4, number 2009-05, FB4 Realty. Item 5, number 773, Scholar Estates. Item 6, the 280A application of Olivia Estates. Part 2, Item 7, number 2010-06, KVC Holdings. Item 8, number 911A, Glen Hill Northern. Item 9, the TDFR application for VIP Real Properties.
Thank you. Is there anyone here to be heard on those applications there to be adjourned? Hearing no motion.
Motion to adjourn the matters that were just read.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered.
Mr. Chairman, we'll move to Part 3 of the agenda. Item 10, number 1136, Hummingbird Estates. The applicant is requesting 2 retroactive extensions of the conditional final approval in order to obtain more time to comply with the requirements of posting the performance bond and filing the map. The map of Hummingbird Estates, number 1136, was granted conditional final approval by the Planning Board on November 2nd, 2011. Town Law, Section 276(7)C, provides that a conditional final subdivision approval expires 180 days after the date of Planning Board approval, but can be extended by the Board with 2 90-day extensions for a total approval period of 1 year. Recent amendments to Section 276 now permits planning boards the ability to grant an unlimited number of 90-day extensions if, in the opinion of the board, the extensions are warranted by the applicant's particular circumstances. Given these changes to Section 276, the applicant is requesting 2 retroactive 90-day extensions of the conditional final approval. The Planning Department has no objection to the applicant's request. The Planning Department offers the following resolution for the Board's consideration. Be it resolved that the Planning Board hereby grants 2 retroactive extensions of time to the conditional final approval for the subdivision known as Map of Hummingbird Estates, number 1136, from November 2nd, 2012 to February 2nd, 2013, and February 2nd, 2013 to May 2nd, 2013.
Thank you. Is there anyone here representing the applicant?
Yes, good evening, Mr. Chairman, members of the board. Excuse me, Anthony Guardino, law firm of Farrell Fritz PC, Uniondale, New York, for the applicant Hummingbird Holdings. I obviously join in the recommendation by planning staff with respect to the request for the extension. I am pleased to report that we were able to also get an extension from the Village of Nessaquag to July 1st. That was voted on Monday night. So now we have some time to complete some of the requirements that we have to complete. I have been advised by my clients that the bond the security has been posted already. So that's already been taken care of. So we're getting very close. We really just need to file the map. And that gets to the second part of the application, which is the request for the waiver of the condition that required the execution of a road maintenance agreement prior to the filing of the final plat with Suffolk County. I don't know if the board wants me to go through it again. I don't think I need to, but
Why don't we handle?
There's another memo. So
oh, you have another memo? Then let me. I'll be,
Okay.
Sorry. Okay. I have nothing else on the waiver. I
Okay.
mean, on the extension, I should say.
Thank you.
Thank you.
Is there anyone in the audience that wishes to talk on this application? Members of the board, any questions? A motion.
In the matter of Hummingbird Estates, number 1136, Motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Mr. Chairman, the next item on the agenda under Part 3, Item 11, number 1136 Hummingbird Estates. The applicant is requesting to waive a condition of final approval for the subdivision known as Hummingbird Estates number 1136. The map of Hummingbird Estates was granted conditional final approval by the Planning Board on November 2nd, 2011. This application was approved for a 3-lot subdivision on a 6.152-acre parcel fronting on Branglebrink Road, a private road located within the villages of Nissaquag and Head of the Harbor and the town of Smithtown. At that time, the board placed conditions on the final map to be filed with the Suffolk County Clerk. Specifically, Condition L states, "The applicant shall execute an agreement with the town regarding the maintenance and repair of the town-owned portion of Branglebrink Road prior to signing of the map." Additionally, the applicant of the approved subdivision known as Map of Tahami Plat number 1135 shall be required to execute the same agreement prior to the signing of the Map of Tahami Plat. The applicant is requesting the board waive Condition L because both parties, the developer of Tahami Plat and the applicant, cannot successfully negotiate a road maintenance agreement to present to the town. The engineering and traffic safety departments have no objection to the waiver request. The highway superintendent has notified planning that Branglebrink Road should remain private. Further, he will not accept this road for dedication, nor will the highway department maintain this road insofar it is not near any other town roads. The planning department is concerned over the future maintenance of this roadway and is currently working with the town attorney's office to transfer the right-of-way to the adjacent property owners. The planning department understands that the board wishes to approve this request and offers the following resolution for the board's consideration. Be it resolved that the planning board hereby approves the request of Hummingbird Holdings, LLC, to waive Condition L of the final subdivision known as Hummingbird Estates number 1136.
Thank you. Counsel?
Thank you. Do I need to repeat my appearance or no?
Just whatever you want to say.
Well, no, do I need to repeat my name for
Well,
this
no, I
part?
think
Okay,
he knows
Anthony
who you are.
Guardino, law firm Farrell Fritz PC, again for Hummingbird Holdings. I hear the recommendation of the of planning staff. Again, we join in that. It sounds like they're amenable to having that condition waived. I went through this last time. I don't think I need to belabor the issue. You know the story here, so I really have nothing further to add, unless the board has any questions.
Okay.
Thank you.
Is there anyone who wishes to hear on this application? Members of the board, any questions? A motion for the waiver of subparagraph L.
In the matter of Hummingbird Estates number 1136, I move that we adopt the resolution as read according to the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? So ordered. We thank you.
Mr. Chairman, the next item on the agenda under Part 3, Item 12, number 1151 Southern Boulevard Industrial Park. The applicant is requesting final approval to subdivide 1.96-acre partially developed parcel into 2 commercial lots. In order to construct this subdivision, a variance from the Board of Zoning Appeals to reduce the total minimum required lot area due to environmentally sensitive lands is required. Before the BZA can act, it is required by Section 277(6) of Town Law to consider the Planning Board's comments to the BZA. The subject property is comprised from one tax lot that is rectangular in shape. There is an existing 5,870 square foot medical office building on the proposed lot number 1, and the applicant is proposing future construction of a 5,580 square foot office building on the proposed lot number 2. The property has 611 feet of road frontage on Southern Boulevard. The site is surrounded by property zoned wholesale service industry, 20,000 square feet minimum, and light industrial, 80,000 square feet minimum. The proposal appears to meet the definition of a planned industrial park as outlined in sections 322-3 and 322-24 of the Town Code. A copy of the ordinance is attached to your memorandum. While the proposal appears to meet the lot area requirements for a planned industrial park, the property contains environmentally sensitive lands, steep slopes in excess of 15% on the proposed lot number 2. In calculating the amount of buildable lot area for a particular parcel, all ESL must be excluded when determining yield. Lot number 1 is approximately 45,300 square feet, and lot number 2 is approximately 42,500 square feet. The average size of both lots is 43,900 square feet, which meets the minimum requirements of 43,560 square feet per lot for a planned industrial park. Lot number 2 contains approximately 6,400 square feet of ESL, reducing the lot area to approximately 37,500 square feet. Pursuant to Section 322-10 of the Building Zone Ordinance, the Planning Board may credit 50% of the ESL toward the lot area. However, since the property is 2 acres in size, this credit, if granted, would still result in a 3,200 square foot shortage in lot area. In order to meet the minimum lot area requirements for subdividing the property as a planned industrial park, the applicant must be granted a variance from the BZA and Planning Board to reduce the minimum required lot area for a 2-lot subdivision in the LI district from 87,200 square feet to 80,720 square feet due to environmentally sensitive lands. The Engineering, Highway, and Traffic Safety Departments have no objections to the applicant's request. The Planning Department has reviewed the applicant's proposal and determined that, while the applicant cannot meet the minimum lot area requirements for a planned industrial park due to the ESL, the variance request is minor in nature due to the fact that the majority of the steep slopes are limited to the northeast corner of lot number 2. As such, the property could be developed with little to no disturbance to the steep slopes. Therefore, if the variances are granted, planning believes that they will not produce an undesirable impact on the surrounding properties. Since the only way to subdivide this property is by this variance, there are no alternatives left to the applicant. The variance is not substantial in nature in that the actual 1-acre density standard is met because the property is 2 acres in size. While the variance involves environmentally sensitive land, the ESL is small and could easily be avoided when the surrounding property is developed. Finally, while the difficulty is self-created, none of the other variance standards appear to warrant denial. Therefore, planning believes that the granting of this variance is warranted. It should be noted that the original lot area requirements for LI in a planning industrial park was 2 acres or 87,160 square feet, while the lot area requirement in a planned industrial park was 43,560 square feet or 1/2 of the normal LI requirement. In the 1990s, this lot area requirement for a lot not in a planned industrial park was changed to 80,000 square feet because commercial properties are generally represented as 1 acre or 40,000 square feet, even though the actual measurement is 43,560. The 1-acre standard for a lot in a planned industrial park should have also been modified to reduce the minimum lot area from 43,560 to 40,000 square feet, but this change was overlooked. The Planning Department offers the following resolution for the Board's consideration. Be it resolved that the Planning Board hereby makes a recommendation to the Board of Zoning Appeals to reduce the total minimum required lot area from 87,120 square feet to 80,720 square feet due to environmentally sensitive lands, slopes in excess of 15%, within the proposed subdivision known as Southern Boulevard Industrial Park, number 1151.
Thank you. Is there anyone here representing the applicant?
Yes, Mr. Chairman, good evening. My name is Vincent Pizzulli. I'm the attorney for the applicant, 55 Southern Boulevard LLC, and my offices are at 333 Earl Ovington Boulevard in Uniondale, New York. I will not belabor the hearing tonight with repeating myself. The planning staff memo is extremely comprehensive and accurate, with one exception. There is no actual construction proposed at this time. We've not yet formed, my client has not yet decided to develop this lot. We're merely seeking a subdivision to create the lot. However, this application does, I believe, meet the standard of the law set forth in 276 of the town law And clearly, the granting of the variances, the benefit to the applicant will outweigh any detriment to the community. The property is zoned light industrial. It's surrounded by the Cider lumber property. On the east, it's bordered by another medical office park on the south. This proposal is consistent with the development of the surrounding area, and we ask this board for its recommendation to the zoning board so that we can secure final approval. Before I finish, Mr. DeRubius, I do have one question. Even with the granting of the variance, assuming that this board recommends it, the lot area of Lot 2 will still be slightly less than 43,560. Should we indicate that as a modification on the map?
Yes, that's the
Okay.
short answer. Yes, it has to be on there. It's going to be average. We're going to average the density anyways. but
Anyway, right.
Yes,
But
it
we
should be
should
listed.
show it so that when the owner goes to apply for a building permit, the building department will have a record of this lot being approved at less than 1 acre.
That's correct. That's why it's on the maps, and the building department will have a copy of that.
Thank you.
Okay.
I have nothing to add if the board has any questions.
Is there anyone in the audience that wishes to talk on this application? Hearing none, anything from the board members? Any questions?
I have just one question. When we say the condition is self-created, that's by virtue of the fact that you're looking to subdivide.
Yes, you could interpret it that way. I don't. That's the word. I'm not taking issue with the staff's comment. That's the fifth criteria for variances. In my professional opinion, the difficulty was not self-created. It's due to an existing topographical condition. We have 6,000 square feet of steep slopes on the northern corner of the property.
That was my next question. You're not responsible for those slopes in any way. It was a natural condition.
That is correct, sir.
Thank you.
Any other questions? A motion for the variance on 1151 Southern Boulevard.
In the matter of Southern Boulevard Industrial Park, number 1151, I move that we adopt the resolution as read in accordance with the recommendations of the Planning Department.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered.
Mr. Chairman, Mr. DeRubius, does this also constitute the hearing for final approval, or will we have to advertise another hearing to approve the final map?
We have to bring, after the Board of Appeals, we bring it back to this board for the hearing.
Okay.
Okay?
Thank you. Thank you very much. Have a good night, and I hope you fare well tomorrow.
Good night. You too.
Thank you.
Thank
Yeah, thank you.
All right, there's an addition there to the agenda for the performance bond that we did for Henning Estates. It has to be amended and then corrected. So,
Yes, Mr.
Ray,
Chairman.
will you read that, please?
Certainly. Just so that the board is familiar with what happened, the board did approve the subdivision at the previous planning board meeting, the February 20th planning board meeting, Heineck Estates. Inadvertently, the highway department had made some mathematical errors on the performance bond estimate when adding numbers together. It was brought to our attention as of today, and we put together a amended resolution for the board to pass so that the chairman can actually sign the performance bond. Be it resolved that the chairman of the planning board be authorized to sign the performance bond estimate for the map of Heineck Estates number 1149 in the amount of $13,195, establishing an inspection fee of $1,085, a cash deposit of $1,000. Therefore, the amount of the performance bond to be posted with the town shall be $12,195.
All right, any questions there on the amendment to that performance bond? Nobody here representing them? No. All right, it's just an amendment there to the bond. Any problems there with the board there to amend it?
No.
A motion.
Motion to approve the performance bond estimate for the map of Heineck Estates, number 1149, in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered.
Done formally.
I have a couple of letters here from, one from the state of New York that was addressed to Blaze concerning the concerning the Yellowtop Farm Estates and the inquiry about the performance bond that had been paid, and apparently that at one of the last meetings there, Frank had indicated that there's some question with the state about that. Is this sufficient there, or are we going to have to have counsel there review this?
No, we think it's sufficient. There's a couple questions we want to ask the state, but we're planning to advertise that for the next planning board meeting so that the board could pass on this.
Well, what we're going to have is counsel there inquire onto the...
Certainly, I have no problems with that.
Okay.
Mm-hmm.
Counsel, did you get a copy of this letter?
Yes, I did.
Would you inquire about that application there and what can be done with it by the board? Okay?
Okay, I'll look into that.
And the other one was from Mr. Tramarco to Mr. DeRubis, and that's the change of zone petitions that we had started to have a hearing on, but we only got one part of it done. And that is he wanted to adjourn the public hearing of that until November the 20th, 2013. Any problems with that?
That's a letter to you. I have no problems
It's
with
it's a letter to you, but I don't know if you've gotten it.
No, I'm aware of it. What I would, we gave that to the board because I think it's CC'd to you as well at the bottom. I believe so.
No,
And-
it's not CC to me, but that's all right.
Okay, I thought it was. In any event, if the board is of a mind to do that, then my recommendation is we have to have that as an advertised matter. This is a
Okay.
rather, I'd have no problem in advertising that for the next meeting, if that's the case.
Oh, to
But this,
adjourn it? We have to advertise it to adjourn it?
yes. This is an action on, you had previously postponed that by meetings to specific dates.
What if we just leave it as is right now? Do
And
nothing?
then when does it do?
March 20th, I believe. Yes, the next meeting.
Does it have to have an advertisement on it?
In my judgment, yes. I'll defer to the council to
Just
it,
for an
but
adjournment? Because it's going to stir up all kinds of unnecessary angst, I think, just for an adjournment. I mean,
but exactly for the reasons that you're mentioning, this is a case of some notoriety, and you know an act in my judgment, although I'll defer to council on this, is that when you take actions on these particular matters, they must be done in the public setting. I mean, the request has been put forth. You know, it has to be notified to the public because this is a zone change matter,
Okay.
and the public has a right to address
sure.
even an adjournment.
If we don't do that, though, if we just have Mr. Tramarco come in on the 20th, nothing's advertised? Is that accurate, or?
Well, I had said that I'm going to request him to post the meeting. It does not require it to be advertised again because it's an active item on the agenda.
So he could come in on the 20th, request his adjournment, and there would be no notice?
If the board, legally, there's two things that you're asking. Legally, what is the board required to do? You're not required to do anything because the matter is always active and you just may open up the meeting at will. Does not have to be posted, does not have to be noticed because it's already currently on your agenda. So if the board wants that, you can have it that way. Given the fact that this is a issue within the community, and we have always said with controversial matters, such as even with other things that have come before the board, while we don't advertise these items, we do have the owner post it as a property, and more as a courtesy to the surrounding residents. And the other thing is that this will be advertised in the planning board agendas online. So, you know, I would recommend to the board that we go through with the posting, our normal procedures, and we treat it the normal way that we normally do. And We'll note that the applicant has requested an adjournment, and the board is going to be considering it at that meeting, and that will be the subject of the hearing.
When
You're
is
gonna be
the,
getting
app-
the
when
calls.
is his, excuse me,
I'm sorry.
go ahead. When was his application over? In other words, we had adjourned only half of this. We had heard the FB4, but we didn't hear the GMF, correct?
Right.
That's
So-
correct.
So when does that run out in time, that hearing?
It doesn't. This
It
is
doesn't.
no, a zone change matter is a legislative act, and as such, it could go on for as long as,
So why does he
Legis-
have to ask for a?
no, because we specifically, you adjourned it to a date. He came, and I believe it was last November.
Yeah.
And then he came in and requested another adjournment, and we adjourned it to March.
Oh,
And
that's what I'm asking.
yes.
Okay,
So this is the third request for an adjournment.
okay.
And this is up to the board. You may grant it, you may deny it, you may do anything you wish for that.
you
But I
feel-
do believe,
You feel even though we may not be legally required to have it advertised, it's better practice to do that, to give the public notice.
yes.
And your posting is going to state that in connection with an adjournment.
Well, the posting just notifies, it's a big sign that just notifies there's an action before the planning board, and it gives a number on there. And then the people either call our office or they go online to check to see what what it's for. We will be advertising this as a request to extend the adjournment date. So if somebody calls up, they will know that.
Any other questions by the board?
No.
A motion then for,
Do we need a motion now?
do we need a motion on it, or just a request there to have
No.
him
I
Just-
will,
Just calendar it?
notify him?
I'm going to put it, it's going to be on the next planning board anyways,
Okay,
so I'll put it on there, but I'll put it under a request for an adjournment,
okay,
Okay.
because the applicant has requested that, okay?
okay.
And so it's going to be advertised then?
Well, it's going to be on our agenda.
Right.
And our agenda is
Right,
advertised.
okay, that's fine.
It's not a formal legal notice. We have two different things. We advertise the board's agenda, goes on, and then there's the legal notification. It does not need to legally be,
There's not going to be a sign at the property?
no, I'm going to want to have
Oh,
a
there is.
posted sign.
Okay.
Okay.
Okay, but the only advertisement that's going to happen is going to be on the town board agenda, the town board internet site. There will not be a legal notice in the newspaper.
Anybody who calls you, though, is going to be told that it's in connection with an adjournment.
That's correct.
So we don't unduly rouse public concern over what's probably.
Believe
gonna
me,
be-
they'll know, this group will know, you know, everybody knows what's going on.
they
They're going to
already-
know what's going to happen 5 minutes after they see something go up, okay?
All right, adoption of the minutes of February the 6th. A
Oh.
motion?
Motion to adopt the minutes of February 6, 2013.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered. Motion to adjourn.
Motion to adjourn.
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered.